Module 3, Crime and Punishment in the American Criminal Justice System. Our sources for this presentation include our textbook, Criminal Law for Criminal Justice Professionals, the 5th edition, and the Louisiana Revised Statutes, Title 14, Criminal Law, Chapter 1, Criminal Code, Article 1, and following articles. In this module, you'll learn to define the two theories that have been applied to justify punishment in the American criminal justice system, identify the 6 types of sentencing applied in our system, explain the common alternatives to imprisonment, and define the concept of proportionality applied to death penalty cases. Punishment is defined in the criminal justice system as when an agent of the government, using authority granted by virtue of a legal criminal conviction, intentionally inflicts pain, loss of liberty, or some other unpleasant consequence on the person who has been convicted. Punishment in our system is relative. The guilty party may be able to easily afford a fine, which is a form of punishment. So is it really punishment for the crime? What about minimal prison time, probation, or community service? Is this actually punishment at all for the crime that was committed? There are 2 theories of punishment that have evolved through our criminal justice system in the United States. The first is the utilitarian justification, which was put into place in the 1900s and followed all the way up to 1970. A practice is desirable under this justification if it promotes happiness more effectively than other alternatives. You go back to Jeremy Bentham's moral desirability test. What is the greatest good for the greatest number of people? The modern interpretation of the utilitarian justification is that the consequences of the act determine the morality of the action. The consequences of potential punishment under this utilitarian justification are general deterrence. This is that the punishment of the offender causes others to refrain from criminal behavior. Individual deterrence. The punishment of the offender will keep the offender from committing the criminal act or other criminal acts again. Incapacitation. This is the restriction of the offender's freedom, usually through imprisonment, things like the 0 tolerance and 3 strikes laws. Another consequence of punishment is reform. This is the rehabilitation of offenders so he or she will no longer desire to commit criminal acts. For example, things like drug treatment, psychiatric services, vocational training, and the like. Another consequence of punishment is vengeance, that imposing of a sentence is retribution for a criminal act. In terms of the old adage, eye for an eye. Vengeance benefits victims, families, and the public. The second theory is the retributive justification. And this came about in the 1970s and is still ongoing today. The offender deserves the punishment that they receive. They are getting their just deserts. The moral approach to this justification comes from Immanuel Kant, that punishment is a restoration of moral order that's been breached by the offender against society. There's a societal duty to punish the offender, and that punishment promotes free will. The social norm approach within this justification is that offenders deserve the punishment because they have violated social norms. This approach avoids any questions of morality and the imposition of morality into criminal law. So there are several types of sentencing utilized in our American criminal justice system. The first is indeterminate sentencing, and this was the predominant approach within our criminal justice system at one time. The principal features of indeterminate sentencing are that the total sentencing discretion is provided to the trial judge, all the way from no punishment in the form of jail time all the way up to the maximum allowable. This sentencing discretion was based upon information presented at a sentencing hearing, such as the offender's life circumstances, their criminal history, any behavioral issues that they might have, and what rehabilitation needs that the offender may have. During this period, this application of indeterminate sentencing, parole boards and corrections officials had the power to release prisoners on their own accord if they felt that rehabilitative goals have been met. Within this framework of sentencing is the belief that offenders can be reformed. The second type is determinate sentencing, and this is a trend that began in the 1970s and was a response to overall disappointment with the use of judicial discretion and the power of parole boards and corrections officials in releasing prisoners early. What you had as a result of indeterminate sentencing was often high recidivism, political and societal pressures to increase sentencing that all led to this transition, this trend to determinate sentencing. This type of sentencing led to creation of sentencing ranges for offenses, or what we know as sentencing guidelines. In 1978, Minnesota was the first state to enact sentencing guidelines at the state level. And then in 1984, the federal government enacted guidelines via the Sentencing Reform Act, which basically established the U.S. Sentencing Commission, who was responsible for in turn establishing federal sentencing guidelines. The primary feature of determinate sentencing is that there was less discretion for judges, that the sentence was determined at the time of sentencing based upon the guidelines. Another type of sentencing is what's known as mandatory sentencing, and this type has become popular in recent years. This has come about through the flexing of the will of legislatures across the country to set the exact penalties or minimum penalties for certain crimes. Mandatory sentencing, however, can be found in both the indeterminate and determinate systems of sentencing. Another type is habitual offender laws, and these types of laws are used in many states and offer enhanced sentencing for repeat offenders. Three strikes laws, you may have heard that term before, were a legislative response to the outcry and concerns of the public over crime. A three strikes law, in a sense, means that if an offender has a conviction of a third felony after previous convictions of a serious or violent felony, this resulted in mandatory life in prison. Now, it's interesting and important for you to know that strikes, the number of strikes vary from state to state. There's no uniformity in that. Some have 2 strikes, while some states have 4 strikes as a part of their habitual offender laws. This is the incapacitation justification for punishment, that if you take the offender off the street for the remainder of their natural life, that they won't commit crime again. Under habitual offender laws, the judge has little to no discretion once all the strikes have been proven by the prosecutor. And an important note is that the prosecutor can decide or not to decide to charge a particular strike. They may reduce a crime to a misdemeanor or not impose it as a violent felony. And the judge can also reduce a strike to a misdemeanor. So habitual offender laws have been challenged in the United States Supreme Court under cruel and unusual punishment challenges to the 8th Amendment and have withstood those challenges. But what habitual offender laws have done most certainly has increased prison populations in most if not all states that have habitual offender laws. Another type of sentencing, we talked about sentencing guidelines. Under the federal system, the Sentencing Reform Act of 1984 created, again, the U.S. Sentencing Commission that developed those federal guidelines. But in 2005, United States versus Booker, the court held that federal sentencing guidelines violated a defendant's Sixth Amendment guarantee of a trial by jury. So basically, after Booker, federal sentencing guidelines became advisory and not binding. However, they are still closely followed by judges at the federal level. At the state level, sentencing guidelines were affected by Booker and other cases like Apprendi versus New Jersey and Blakely versus Washington, Cunningham versus California, and others. So throughout these judicial reviews, some states have determined that the guidelines violated the right to jury trial, while others have said that enough discretion exists within the guidelines for judges. Let's move on to alternatives to imprisonment. And the first alternative is pretty familiar to most of you in criminal justice as probation and parole. There are millions of offenders that are under supervision across this country in lieu of being in a prison. And there are two types of this supervision. The first being probation. Probation is a suspension of a sentence of incarceration. So an offender is convicted and they're placed on probation instead of actually being incarcerated in a prison or a jail. This allows the offender to return to the community, but under strict conditions, like they have to obey the laws, they can't be arrested or convicted of another crime, stay away from specific people or types of people. They have to have gainful employment, maybe conduct community service, undergo pretty extensive drug testing and counseling services or other conditions. People on probation are generally under the supervision of a probation officer, either from the local or parish corrections agency, or even from the state probation and parole office. Now, parole is a little bit different, similar but different. Parole is instituted when an offender actually goes to prison or incarcerated for an amount of time. But parole is this release prior to the expiration of the full term of incarceration. It allows the offender again to return into the community under certain conditions and they're very similar to probation conditions, but they carry out the remainder of their sentence while in the community. And they're heavily supervised by a member of the state corrections department, a parole agent. Another alternative to imprisonment is what's known as restorative justice. This is a process through which all parties with a stake in a particular offense, they come together to resolve the issues collectively on how to go about and proceed with things after the offense has occurred and what implications will occur in the future. In restorative justice, the victim takes a very active role in the punishment decision. The offender gets to hear from the victim of what the crime has meant to the victim's life, and provides the opportunity for the victim to ask the offender questions. Alternatively, the offender can explain his or her actions and what punishment will mean to them. And during this process of restorative justice, the offender can offer some type of retribution, like compensation or other retribution. Wrongful convictions are also significant in the justice system and are a prominent example of injustice. A wrongful conviction the conviction of an innocent person is one that no member of the criminal justice community wants to occur. What has led to an uptick in wrongful conviction decisions has been, quite frankly, advancements in scientific analysis and the manner in which DNA is collected, it's preserved, and it's analyzed. But there are a lot of factors that lead to wrongful convictions. You have prosecutorial misconduct. So sometimes a prosecutor will fail to disclose evidence that's beneficial to the defendant. Exculpatory evidence is what that's called. Prosecutors may introduce false evidence and may display discrimination in jury selection. On the flip side to prosecutorial misconduct is ineffective defense counsel, which leads to wrongful convictions. You may have inadequate investigation and preparation for the case on the part of the defense. They may fail to raise appropriate motions and objections during the trial process. They may fail to address prosecutorial or jury misconduct itself. A third factor leading to wrongful convictions is police corruption. Police may plant evidence, improperly use information from informants, make an attempt to intimidate witnesses, and of course, improper interrogation methods. You may have a jury that's vengeful. You may have members of a jury that may have passed muster during voir dire, that maybe held some prejudice toward a defendant, or even someone on the defendant's defense team, and they retribute vengeance upon the defendant during the jury process. Wrongful convictions also come about due to racism, sexism, and other isms. There may be inaccurate eyewitness testimony during the trial process that could lead to a wrongful conviction, and false confessions on the part of the defendant as well may lead to a wrongful conviction. The remedy right now is usually compensation for a wrongful conviction, in which a wrongfully convicted defendant can sue the jurisdiction that led to his or her incarceration. Let's take a minute to discuss the death penalty, which in our criminal justice system and others around the world is the ultimate and most controversial form of punishment. It's controversial because some think that it should be abolished. Some think that it should be used more, and some think that it should only be used depending on the crime or the particular offender. 29 states, the federal government, and the military have the death penalty, and that statistic is as of 2019. And I will tell you that in those states that do have the death penalty, there is a significant effort to repeal those statutes at every opportunity across the country. Most states impose the death penalty only for certain grades of homicide. And of course, lethal injection is used as the manner of imposition of the penalty in most states. However, some states do still have other forms on their statutes. Lethal injection is used in most states. The death penalty came to the American colonies, just like many other laws and aspects of laws, as part of English common law, but has been limited, more and more limited to certain crimes over time. And states have developed their own death penalty laws, which leads to this wide variance in application and scope. The death penalty remains pretty steadfast in the southeastern part of the United States and in Texas, which has accumulated and accounted for 37% of all executions in the United States since 1977. The death penalty is still legal in the lower Midwestern and Western United States, but moratoriums have been in place for some time. For example, in 1972, the California Supreme Court declared the death penalty unconstitutional and reduced all defendants with a death sentence to a life in prison sentence. In terms of judicial scrutiny and proportionality, the death penalty is subject to evaluation based upon the cruel and unusual punishment clause of the Eighth Amendment. In 1910, the U.S. Supreme Court reviewed the case Weems versus the United States, and reviewed this case on the concept of proportionality. Does the punishment fit the crime? Is essentially what proportionality means, and that punishment must not grossly be disproportionate to the crime. So this concept of proportionality began to be applied to death penalty cases in the early 1970s. The court began considering death penalty cases in Furman versus Georgia in 1972, and they held that and found that the imposition of the death penalty in 3 very specific and different cases was arbitrary and capricious, and that the death penalty was excessive because it failed to further the goal of punishment. Well, Furman didn't end the death penalty. It basically sent the states into review, and many states who wanted to use and continue to use the death penalty as a form of punishment went into revision of their death penalty statutes, which ultimately set the stage for even more challenges. So in 1976, after the states reviewed and revised their death penalty statutes, the challenge to many of these state statutes came in Craig versus Georgia in 1976, where the court took into account revisions of death penalty statutes across many states and ruled that the death penalty itself did not violate the U.S. Constitution. So proportionality shifted to the imposition of death penalties for the death penalty for certain crimes and for certain classes of defendants. So accomplices to murder at one time were subject to the death penalty, but in Inman versus Florida in 1982 and Tyson versus Arizona in 1987, the court established a requirement that the state has to show that the accomplice had themselves the intent to kill, and they were a major participant in the crime while showing this reckless indifference to human life. Classes of defendants were challenged in Roper versus Simmons in 2005 and Atkins versus Virginia in 2002. So in Roper, the court held that the state could not execute a defendant who was under 18 when the crime was committed. And then Atkins held that the death penalty couldn't be imposed on a defendant that was mentally challenged. And then as early as 1977, a challenge to certain types other than homicides, in which the court declared the death penalty was unconstitutional when applied to the rape of an adult woman. And that decision was in Coker versus Georgia, as I said, in 1977. So in this module, you learn to define the 2 theories that have been applied to justify punishment in our criminal justice system, identify the 6 types of sentencing applied in our criminal justice system, explain some common alternatives to imprisonment, and define the concept of proportionality applied to death penalty cases.